With complaints filed in New York, what you will commonly see is a cause of action for one, a violation of the New York State human rights law, and then two, a violation of the New York City human rights law. And so, as the names indicate, the difference is negligible. The difference is one applies statewide and one applies to New York City. And so, while the language may not be exactly the same, the sentiment is very similar, and that is that both laws protect against discrimination of protected classes. And so, protected classes include age, disability, of course, race, sexual orientation, etc. But what's important and relevant to this channel is that disability is protected in places of public accommodation. And so again, the same theme is we're seeing the language from the Americans with Disabilities Act incorporated into these laws. And so whereas the Americans with Disabilities Act is specific to disability, these laws are specific to discrimination of any number of protected classes, but we see disability comes up, and then plaintiffs' law firms have taken that next step, and they have applied these local laws to websites. And so what's happening is places of public accommodation need to make their accommodations, facilities, etc., so that they can be accessed by people with disabilities. And so the New York State human rights law, and I'll link to, I'm looking at a page right now that has a broad overview of basically a summary of the law, but it lists off restaurants, stores, hospitals, museums, and theaters, and it's saying that these places need to have reasonable accommodations. Well, what happens is plaintiffs' law firms have extended this, and they are saying, well, websites also need to make sure that they're accessible, and if they're not, they're in violation of not only, sometimes they'll say it's the New York State human rights law, but not only that law, but also the city law as well. And the same or very similar logic is used with these laws as it is the Americans with Disabilities Act. So when it comes to website accessibility, we not only see the ADA being cited as a cause of action, but these state and now city laws are being cited because one, it makes the complaint stronger, but two, it provides for damages, whereas the Americans with Disabilities Act does not provide damages for the plaintiff. It provides for injunctions, injunctive relief. Now we have these local laws, and they do provide for damages, so it's more lucrative to file complaints with causes of actions under these laws. And so what you'll see is the plaintiffs' law firms will have causes of actions under the Americans with Disabilities Act as well as the New York State and City human rights law. So I will link to the sources below where you can read the law, but that's what's happening with the New York City human rights law.